2015, there was an uproar in the country when Bunya Jalung, a 60-year-old man, was acquitted of all charges of rape. He was convicted in 2013 of raping a 15-year-old girl, in a hotel room 4 times. However, he was subsequently acquitted on appeal, even though the DNA testing confirmed him as the father of the child. The reason behind his acquittal was that in Malaysia, the insertion of his finger in the victim's vagina does not constitute rape under Section 375 of the Penal Code. This signifies that the law in Malaysia is perhaps not adequate enough, and hence this begs the question: what amendments should be made to the Penal Code provisions regarding the offence of rape to better the law?
I will further elaborate about the issue of gender in the law of rape. What do we normally associate rape with? Men or penis? Is it true that only men can rape and women will forever be the victim? What is rape? Rape represents an expression of sexual desire and involves violence to terrorize and humiliate a person regardless of gender. However, the current law does not seem to be sufficient in protecting both male and female, as it is too fixated on the word penal penetration, thus being a gender-specific law instead of a gender-neutral one. Rape should not only be applicable to the woman as a victim, it should be applicable to both genders. Section 375 of the Penal Code states that a man is said to commit rape who, except in the case hereinafter accepted, has sexual intercourse with a woman. The weakness of this section is that it does not provide protection to the male and does not take into account of them being the victim. This is because under this section, only the male can be the perpetrator and only the male can be the victim. This has led to DAP Kulai Member of Parliament, Teo Ni Chin, saying that rape should not be limited to penal penetration and it is time to make the crime of rape gender neutral. In regards with general public perception that male cannot be the victim, Malaysian Medical Association MMA President Dr. Thamasiran said that myths surrounding male sexual victims are centered on cultural and sexual stereotypes that the society holds against victims, which further elaborate that male can also be damaged by society refusal or reluctance to accept their victimization and thus must tough it out in silence. To amend the unfairness of the current law towards the male gender in this scenario, we propose this rape section to be amended to a person is said to commit rape who, except in the case hereinafter accepted, has sexual intercourse with another person. The impact of this amendment will not take gender into account. The law has to be in line with the fast-changing culture of society. With the emergence of homosexuals and transgenders, rape should also include men as a victim and the possibility of a woman being the perpetrator. The legal gender of the perpetrator would not be an issue of debates by the court anymore if gender-specific law were to be abolished. In England at present, it is not important to determine whether the victim is a man or woman, but a person who has the physical appearance or physical attributes of a man or woman, but the fact in issue is whether the crime was committed. To further elaborate issues arise from gender-specific law, it had been shown in the recent Singapore case of Zunika Ahmad, decided on 12 April 2016. The brief fact of this case is that a Singaporean woman who lived off as a man has been acquitted of sexual assaulting a 13-year-old girl because the judge said that rape law, on which the charges were based on, relates only to men with penis. This landmark ruling shocked the public as the High Court Judge Kang Ting Chiu said that Singapore Penal Code provision under which she was charged is only applicable to males. In the end, she was jailed for only 8 months with a lesser charge of obscene act towards minor, which the provision itself is gender neutral. The judge stated that the better course was to leave it to the legislature to amend the provision to make it clear that person A includes a woman if there was indeed the intention of the parliament. Subsequently, after this case incident, Singapore Management University Associate Law Professor Eugene Tan said lawmakers could add another provision to the section to include woman or amend it to make it gender neutral. Agreeing that the law should be reviewed, criminal lawyer Louis Joseph said, criminals now move faster than the law in this age of the internet, but with experience, Parliament will learn and modify things. And in regards with the gender neutrality issue in the United Kingdom, in 1977, which is the famous Mormon sex lynching case, was the first ever male victim rape case being widely publicized by the media, where the perpetrator, Joyce McKinney, chained her victim to the bed and forced him to have sexual intercourse with her. However, eventually, due to victim gender, legally speaking, no rape has been committed, and only indecent assault of a man applied, which ended up in a 1 year of jail sentence. This problematic issue of law in this country is similar to Malaysia, as our current law only limits males as the perpetrator. And a thing to add on, Article 8, subsection 2 of the Federal Constitution state that there should not be any discrimination towards gender in law, and therefore gender-neutral provisions should be encouraged towards the amendment of law, as both gender is vulnerable to rape. The law must be amended to keep up to date with the changing culture and acts of society, to protect the interests of the public and particularly the victims.
The main issue with Section 375 of the Penal Code is the word sexual intercourse, and it is most visibly observed in the case of Punya Jalong, as he was acquitted due to the absence of insertion of penis. As of the current law, a man is said to commit rape who, except in the case hereinafter accepted, has sexual intercourse with a woman. Based on the explanation in the Penal Code, penetration is sufficient to constitute the sexual intercourse necessary to the offence of rape. Besides, sexual intercourse, according to Housebury's Law of Malaysia, is penetration of penis into the vagina. As displayed in the Punya Jalong case, the accused was acquitted due to the fact that finger rape does not fall under penal penetration, which is the essential element required to fulfill offence of rape, and therefore was eventually acquitted. This incident resulted the law of rape to fall into a mess of array and have sparked public controversy, including statements from political party where MCA Wanita says that it shouldn't just include the penis but other male body parts. Besides, Citizens Against Rape also stated that it should include penetration using a body part, object, or orally. At the same time, the World Health Organization also defines rape as physically forced or otherwise coerced penetration, even if it's a slight penetration using a penis, other body parts, or an object. The current legal definition on the word sexual intercourse in the Penal Code is too vague, as it does not have a clear definition in the Penal Code, and one may easily escape the legal responsibility as shown in the case of Punya Jalong. Therefore, this call upon the need to amend the law to make it certain and clear for the public, as well as to assist the Attorney General's chamber to prosecute the accused. Therefore, our proposed amendments on the word sexual intercourse to include insertion of or causing the insertion of the penis, any part of the body or object into vagina, anus, or mouth of another person, and to delete the explanation which says that penetration is sufficient to constitute sexual intercourse. The amendment to the law is imminent, as justice delayed is justice denied. This will lead to injustice merely because the law is not sufficient to protect the victims. Just take an example, the case of Noreen Jaslyn, an 8-year-old girl was sexually abused and murdered. Her body was later found stuffed in a gym bag a month after her abduction, with a cucumber and a brinjal stuffed inside her genitals. Unfortunately, the murder remains unsolved. However, the case has also revealed the limitations of Section 375 of the Penal Code, which only covers penal penetration. In the event that perpetrators in Noreen Jaslyn's case were identified, there is a high possibility that the crime would not be covered by Section 375 of the Penal Code, as stuffing a brinjal and cucumber into a vagina is not penal penetration. Besides, it is noted that the scope of sexual intercourse introduced in Australian law is more expansive for the offence of rape. Sexual intercourse is defined to include penetration not only by the penis but also other bodily parts and objects. Similarly, in New Zealand, the concept of sexual connection is also wider than the sexual penetration as compared to the English law. The sexual connection in New Zealand, in the section 128, subsection 5 of Crimes Act 1961, is defined to include penetration not only by the penis but also other bodily parts and objects. Therefore, the offence of rape should not be limited to penile penetration as the source. With these amendments proposed, the meaning of sexual intercourse under section 375 of the Penal Code has been expanded and is no longer only confined to male penile penetration, but also extended to objects and any part of a person's body, whether it's a male or a female, as long as the act was done to the other person without consent.
The offence of rape in Malaysia is found in section 375 of the Penal Code, and it can carry a maximum penalty of life imprisonment under section 376. However, it is very curious as there is no reference to any mental element in section 375, as it does not prescribe a mens rea for rape. In the federal court case of Adnan bin Khamis versus public prosecutor, Chief Justice Ong stated that an essential element or essential ingredient of all offences under the Penal Code is mens rea, and that it should be construed as connoting fault or blameworthiness of conduct. Thus, this begs the question, what should be the suitable mens rea required for this offence? In distilling the definition of rape from section 375, rape is when a man has sexual intercourse with a woman against her will and or without her consent, with the inclusion of several situations listed under C2F. The phrase against her will under 375A connotes that the intercourse was done by a man with a woman despite her resistance and opposition. However, according to the case of PP versus Victor Raju, physical injury is not a prerequisite for rape. Hence, it can be argued that section 375A is an overcomplication of the law, as the main issue is a lack of consent rather than physical resistance. Section 375A should then perhaps be removed, as the situation in which it covers is already covered by 375B. Similarly, for the sake of clarity, the concept introduced by the case of Augustine Fung Bu Jiang versus PP should be incorporated in section 375, which is that consent always signifies submission, but submission does not always signify consent. This means that the lack of any physical retaliation or resistance does not prove consent conclusively. The main focus should be the lack of consent. Before diving directly to the issue of mens rea, the dominant factor in rape is a lack of consent. Yet, the Penal Code does not prescribe a positive definition for rape. Section 90 only provides for circumstances in which there is no consent. In a situation like this, judicial precedents would normally prescribe a definition, but so far there has been no attempt made by the courts. Additionally, subsection C to G of section 375 should instead be placed under its explanation, as these are merely circumstances in which there would be no consent given. The phrase with a consent and with or without a consent should be removed altogether from section C to F and G, as they are, to borrow from the words of Stanley Yao, inappropriate and semantically curious language. The law should represent the reality of the situations provided in subsection C to F, which is to say that in these circumstances, with her consent would be contradictory, as there would be no true consent given. Hence, we recommend that there be a test of recklessness, which will essentially ask, given all the circumstances known to person A, was it reasonable for person A to think that person B was given consent by person B? I'll take that again. Given all the circumstances known to person A, was it reasonable for person A to think that consent was given by person B? This test would be partly subjective and objective, where the subjective component would be focused on the defendant's perspective, on his actual knowledge of relevant facts. An objective component would be based on what a reasonable person would, by probable reasoning, infer or conclude regarding the nature of the thing concerned. We already know that in criminal law, recklessness is one of the 4 possible classes of mental state constituting mens rea, where the test is based on an assessment of whether the accused had foresight of prohibited consequences and desired to cause those consequences. In our test, the defendant would be capable of raising a defense as to a mistake of fact covered under Section 79 of the Penal Code, which goes on to talk about good faith, which is covered under Section 52. Good faith is when nothing is said to be done or believed in good faith, which is done or believed to be without due care and intention. In the case of R versus Van der Wil, the court not only held that the Crown had the onus of proving that the accused was guilty beyond a reasonable doubt, it was also established that a mistake of fact is not a defense if it arose out of willful blindness, a decision which our test would follow and incorporate. It is stated that willful blindness arises where a person who has become aware of the need for some inquiry declines to make that inquiry because he does not wish to know the truth but would prefer to remain ignorant. It should be noted that in Australia, it has been recognized that rape may be committed intentionally or recklessly. The accused commits rape intentionally where he penetrates the complainant without her consent, intending to penetrate her notwithstanding her lack of consent. He commits rape recklessly where he penetrates the complainant without her consent, foreseeing that she might not be consenting. We submit, therefore, that the mens rea for the offence of rape in the Malaysian Penal Code be intentional penetration by the accused and recklessness as to whether consent was given.
The marital rape exception under Section 375 of the Penal Code should be removed. This exception states that sexual intercourse by a man with his own wife in a marriage which is valid under any written law for the times being enforced or is recognized in Malaysia as valid is not rape. The marital rape exception originated from an archaic British common law concept whereby the wife, upon entering the contract of marriage, is deemed to have been given herself to her husband and is treated as the husband's property. The British marital rape exception was incorporated into Malaysia's penal code and has remained to this day. Malaysia is part of the United Nations, so it should follow certain treaties. One of the treaties is called CEDAW, where members are supposed to criminalize marital rape. Malaysia ratified the convention in 1995, and under the definition of discrimination against women in the convention, discrimination based on the marital status of a woman is included. However, Malaysia has failed to enact legislation criminalizing marital rape, and when questioned in the CEDAW 35th session, a delegate responded by explaining that marital rape could not be made an offence as it would be inconsistent with Sharia law and other religions practiced in Malaysia. However, to compensate for this lacuna in the law, Section 375A was added into the Penal Code, which criminalizes a husband causing hurt in order to have sexual intercourse. We propose that the marital rape exception under Section 375 of the Penal Code should be removed. This is because Section 375A is clearly an ineffective mechanism in preventing rape between husband and wife. The Home Ministry released an astonishing fact, which was that as of June 2015, no man has been convicted under Section 375A since its inclusion in 2007. Evidently, this appalling statistics shows how inadequate Section 375A is as a protection against marital rape. Section 375A was made as a form of compromise between Malaysia's ratification of CEDAW and the Sharia law system, but this makes it clear that it had been completely useless in safeguarding women against violence in their own marital home. Today, there are many countries that have either enacted marital rape laws, repealed marital rape exceptions, or have laws that do not distinguish between marital rape and ordinary rape. The criminalization of marital rape is in these countries, both in Asia and around the world, indicates the marital rape is now recognized as a violation of human rights. The typical stereotype is that marital rape is less traumatic when compared to stranger rape, but studies have shown this to be untrue. Rachel Kennedy Bergen supports this with her statement that marital rape victims are more likely to experience multiple assaults and often suffer severe long-term physical and emotional consequences. The shock, terror, and betrayal experienced by rape survivors are often exacerbated rather than mitigated by the marital relationship. In part, Because of the repeated abuse, these women live in constant terror. Furthermore, in a study made by researchers Jacqueline Campbell and Peggy Alford, the authors found that 5% of the women indicated that their children had been forced by their partners to participate in sexual violence, and 80% of the women indicated that their children had witnessed an incident of marital rape at least once. Marital rape is an increasingly rampant issue and should not be taken lightly. Based on the statistics provided by the Women's Aid Organization, 40% of their cases in the last 5 years include sexual violence within a marriage. The Women's Center of Change in Penang handled 38 cases of marital rape in 2014 alone. Yet, these figures don't rightfully reflect the severity of the problem. Worldwide, cases of domestic violence, let alone marital rape, are grossly underreported. Therefore, we would like to point out that Section 375A is insufficient to protect women, and it clearly shows discrimination against the married woman, as the fact that she is married to the husband offers her less protection under the law, even when the husband is the perpetrator in question. This should not be condoned, and we call for the marital rape exception under Section 375 to be removed.
The core objectives of punishment should be to punish, deter, and to rehabilitate, to adequately reflect the gravity of the crime, as well as to prevent the future occurrence of the crime. Are the current punishments enough to stop violence against victims? Statistics by the Malaysian Police Home Ministry shows that there is an upward trend in rape. Furthermore, in a parliamentary response on 16 June 2014, rape cases in Malaysia, it's around 3,000 per year, which means on average 8 rape cases per day, and according to a report by WAO, only 10% are reported. For one reported case, 5 go unreported. The continuous uprise in rape cases is worrying, and the Select Committee proposes that sentences of different weight is to be imposed on rape in varying circumstances. We would like to propose to amend the punishments on marital rape, repeat offenders, as well as sexual acts involving children. In light of all these negative consequences of marital rape towards the victim, children, and family dynamics, the punishments on the husband under Section 375A is not proportionate towards the gravity of the repercussions that marital rape entails. With the amendment proposed to include marital rape under Section 375, the law should also impose the punishment equally on the husband. Besides, mandatory therapy on the repeat offenders was suggested by some researchers. We recommend that in addition to require offenders to go under police supervision, there should be a mandatory rehabilitative therapy be prescribed within the legislation for sexual offenders. This is because the initial punishment, jail punishment, has not served its purpose as to deter the offenders. Therefore, an additional therapy must be carried out to rehabilitate them. With increased jail sentence for sexual offender is debatable, the government should also consider to implement it, especially where minors are involved. Currently for rape, regardless of the age of the victim, sexual offenders are sentenced to imprisonment for a maximum of 30 years with possible whipping. We propose that any sexual act done on the children must be imposed with the higher sentence. It is quoted that we know that children are easily coerced and manipulated as they are not yet fully mature, which even happens to adults. There should be no grounds to excuse the adults who had intimate sexual contacts with a minor. At times, severe punishment per se may not deter the wrongdoer, but hopefully with the amendments proposed, it may deter others from committing the same offence.
Bunya Jalong has definitely sparked public controversy in regards with our current law of rape. But what is crucial now is that we amend the law accordingly to suit the needs of the society, and therefore what could we conclude after analysing our current law of rape? We have tabulated our proposed amendment in the table below to ease everyone's understanding. Gender-specific law has always been an issue recently due to the uprising cases of female committing sexual offences. With the removal of man and woman wording, the perpetrator and victim can be any gender and thus preventing any offender from escaping liability due to their gender. In regards with sexual intercourse, a proper definition should be added into the penal code to prevent any inconsistency in law. With this new sexual intercourse definition, it has extended all sources of penetration to cover rape instead of just one source, which is the penis. As for the mens rea of rape, a new proposed test for recklessness would be able to clear out the doubts of mens rea in the law of rape. For punishment, it has not served its purpose as to deter the offenders, and therefore mandatory therapy should be carried out to rehabilitate them. The marital rape exception should be removed as Section 375A is clearly an ineffective mechanism in preventing rape between husband and wife. The most startling statistic given by the Home Ministry is that as of June 2015, no man has been convicted under Section 375A since its inclusion in 2007. Thus showing how inadequate Section 375 is as a protection against marital rape. With all these proposed amendments, we hope that it will provide a clearer picture towards the law of rape and cover all types of sexual offences to safeguard the welfare of our citizens.